Welcome back to my channel. My name is Thomas A. Bushnell. I'm an attorney licensed to practice law in Idaho, Washington, and California. Today I'm going to be talking about trusts, specifically a living trust, sometimes referred to as an inter vivos trust. Earlier we talked about wills, and we had a pour-over will that poured all your non-probatable assets into your trust. In your trust already are your probatable assets like your house, maybe some mineral rights, maybe a note on a contract for some land that you sold, and you'll have a bank account in your trust where all your bank accounts will be payable on death of the last of you and your wife or husband to pass away. Everything would then go into the trust. So the next thing I'm going to talk about is how does a trust work? Well, the page should come up and it'll show you that there's the settlers. In California, often they call them grantor. Sometimes they're called trustor. If you're wearing your settler hat, you have three powers. You can create the trust, you can change the trust, and you can cancel the trust. That's the authority you have. Let's put an S here in case you're married. There's settlers, or there's two people. Maybe you're not married, but you're putting your stuff together in a trust. You and your significant other would be the settlers. So who are the settlers? You are the settlers. You're the creators of the trust. You have the power to change it and to cancel it during your lifetimes. Now, every trust has to have a manager. Okay? In law, we call the manager of the trust the trustee. Let's just go in MGR, like Billy Martin, MGR, there we go. So you have a manager of the trust. Who's the manager of the trust? The trustees. We'll make them two, you and your spouse or significant other. So you create the trust, you manage the trust. Then we have the stuff in the trust called the res, sometimes called the corpus, sometimes called the trust property or the trust estate. We can have a house in there with the land and another piece of real property, as many pieces of property you own. We're going to have a bank account in there. You might have some mineral rights. You might have a note secured by a deed of trust. You might have a vehicle in there. Okay. These are the things that could be in your trust. There could be a few other things as well. And then every trust has a creator, every trust has a manager, and every trust has to have a beneficiary. Who's the beneficiary? That is also you. You're the beneficiary. It's a living trust. You create it, you manage it during your lifetime, and you use it however you jolly well want. You're the beneficiary. You use it just like your own money, just like your own house, just like your own car. So let's take and let's fill in the terms of our trust here. Let's get the terms, all right? You can see some of them already. We have the settler, that's you, right? We have the trustee, that's you and your spouse or significant other. The next thing we need. What happens if you and your spouse, or what happens if the settlers become incapacitated or die? You have to have a successor. Successor trustee. Okay, who do you choose for your successor trustee? If your estate is worth less than $1 million, then most professional trustees won't touch it. The bottom line for most professional trustees is $750,000. They prefer $1 million. If you have a professional trustee, they're going to charge you like a 3% of your trust plus an hourly rate. But if you have a substantial estate, then that could very well be what you need. Most people just have one of their children be the successor trustee. So here we'll call Abel, okay? Abel is your child, and that's your successor trustee. So now, we have successor trustee, okay, and that's A. Next, we have the beneficiaries, right? Okay, that's you, all right? You and your spouse or significant other, that's fine. Then you have contingent beneficiaries. What's it contingent upon? It's contingent upon you not being Enoch or Elijah. Those are the only two people in the Bible who never died. It's contingent upon you dying. Once you die, then the contingent beneficiaries become the beneficiaries. You're no longer the beneficiary because you're no longer with us. And let's go Abel, Betty, Charlie, and Don. Okay? So you got the children Abel, Betty, Charlie, and Don are the contingent beneficiaries. They are the beneficiaries after you pass away. So let's see how this works. Here we go. You guys, as the trustee, you and your spouse, or whoever the settlers are normally the trustees, you manage these assets in accordance with these terms that you can change at any time. Remember, you can change it for your own benefit. Okay? Now, what happens if one of you either becomes incapacitated? Then you have the other trustee still manage these assets. Or let's say one of you pass away. And here's where things start to change. The most common way is if a husband or wife pass away, the surviving trustee manages these assets in accordance with these terms, and it's usually she survives, that she can change for her own benefit. Now, sometimes you have blended families, or sometimes you have people coming into a relationship with one having significantly more assets than the other, and they each have children. In that case, what we do is called a Q-tip trust, a qualified terminable trust. Basically, I'm going to give you the sweetened, shortened, condensed version, is that upon the death of the first trustee, the other surviving trustee still manages these assets, but then they would not be able to change the terms. What they're trying to do then is to make it so everything still goes to these folks, Abel, Betty, Charlie, and Delta, because if they can change it, and the spouse then, after you pass away, changes it to her kids and writes out your kids, well, that's not going to be very pleasant. That sometimes we do trusts like that. That's a shortened version. They're a little more complicated than that, but that gets to the idea. There's other types of trusts, like third-party supplemental needs trust. If you have a child with special needs, then we definitely would want to talk about something like that. If you have a child who's blind or something like that. So now, once both the settlers and the trustees have passed away or become incapacitated, let's say the husband dies, he says, here, hold my beer, watch this, does a backflip off a bulkhead, wins a Darwin Award at 58 years old. Really bad idea, folks. And now the wife is still alive. I know women live longer than men. I saw it on YouTube. Okay, so let's say the husband passed away and then the wife becomes incapacitated. She's not quite dead yet, but she's incapacitated. So then the successor trustee takes over and manages these assets according to these terms, which they cannot, may not, and must not change for the benefit of mom, the one who's still alive but incapacitated. Once mom passes away, now Abel, or it could be, for example, you could have Abel and Betty. They could be co-successor trustees. You could have it any way you want. You're the creator, you call the terms. They manage these assets according to these terms, which they cannot, may not, and must not change for the benefit of the contingent beneficiaries. Now, some people like to control from beyond the grave. Don't. There's numerous reasons. The number one reason, lawyers. If you try to control from beyond the grave and have this thing run out several generations, believe me, in several generations there's going to be confusion, there's going to be fighting, and the only one who's going to win is us, the lawyers. Don't do it. Just make it clean. Make it so when your kids pass away, when you pass away, the money goes to them. Now, sometimes you could have a child, maybe they're addicted to drugs. You can change the terms of the trust while you're alive and skip that child and have it go to your grandchild, or make a condition for them to receive their inheritance that they go to drug treatment and they have to have a hair follicle test like 3 months afterwards, and you can encourage them that way to get clean. But obviously you don't want to give $20, $30, $40, $50, $100,000 to a drug addict. It will kill them. So but there's things you can do here to protect your children. So this is the way a trust works, and then after both of you have passed away, and ideally we just distribute. Sometimes we hold it longer if the child has special needs or if they have some other issues that need to be dealt with. So that's the life cycle of a trust.